Oh, it's a pleasure to be here and speaking with you today. I think the sensitivity of many Muslims to negative portrayals of their faith really was drawn to the West's attention in 1988 with the publication of the Satanic Verses by Salman Rushdie. However, it's a phenomenon that goes back a long way. In 1778, Beaumarchais wrote in the Marriage of Figaro a monologue in The Mouth of Figaro, where Figaro comments that if he were to write a play about the Seraglio, passing critical comments about Muhammad, he would in no time at all be receiving representations from far-off places warning him that he defended the Ottoman Empire, Persia, much of India, all of Egypt, as well as Ethiopia, Tripoli, Tunisia, Algeria and Morocco. And it's an interesting thing that this issue of Islamic sensitivity about criticism of Islam and Muhammad is so long-standing and persisting. In fact, the reason for that is that it goes back to theological principles in the very heart of Islam. Muhammad, early in his career, received a lot of opposition, even persecution, and an idea developed as part of Islamic theology that any opposition to Islam and anything that would discourage a Muslim from being confident about being a Muslim was fitna, which means persecution or seduction. And a verse was revealed to Muhammad twice that fitna is worse than slaughter. That is, killing people is not as bad as leading a Muslim away from his faith. And another verse also revealed twice in the Quran was, fight them until there's no more fitna. So Islam took upon itself into the core of its theology a belief that anything that would undermine a Muslim's confidence in their faith was a terrible thing, worse in fact than killing. Now, this fitna worldview, that it's a matter of justice to prevent people from criticising Islam, is being demanded by Muslim authorities as something that the West should adopt. Muslims have been seeking legal redress for insults upon their faith, their God or their prophet. The category of Islamophobia has been promoted to give a focus for this campaign, and in 2005 the Organisation of the Islamic Conference, which is really the UN of the Muslim nations, adopted a 10-year action plan to address challenges facing Muslims in the world today. Item 6 on their plan was to combat Islamophobia, and one of their strategies is to get the United Nations to adopt, I quote, an international resolution of Islamophobia and call on all states to enact laws to counter it, including deterrent punishments. After this, the OIC's, the Organisation of the Islamic Conference's Anti-Defamation of Religion resolutions, after they were passed by the OIC, they were then adopted by the UN Human Rights Council and then at the General Assembly of the UN in December 2007. And the purpose of these initiatives is to enforce theological limitations on critical speech about Islam as a part of international law. But let me turn to Australia and the way in which some of this pressure has been played out in the application of the Racial and Religious Tolerance Act of the State of Victoria, brought in 2001. This law is an example of what's come to be called religious vilification legislation, and it's based ultimately on anti-racism legislation. Just a word of clarification, although these laws are often referred as anti-vilification laws, in ordinary English, vilification means something like defamation. That is, saying viciously untrue things about people that hurt their reputation. But in fact, these laws are usually not about defamatory statements, but are about incitement, which is quite a different thing. And incitement, the concept of incitement is taken over from anti-racism legislation. The difference is that incitement can in fact use truthful statements to incite negative feelings. For example, you could say the French eat snails or Koreans eat dogs. Statements like that, although strictly speaking true, could be used to incite negative stereotypes. And usually anti-incitement or religious vilification legislation is worded in such a way that even if the behaviour that you indulge in is truthful, it could still be illegal if it incites negative feelings in people. So that's different from the Western tradition of defamation law, in which truth is a defence. Usually these laws allow some exceptions because, in fact, this is a restriction on people's ability to speak the truth safely. There are usually exceptions built into them, allowing incitement for certain purposes such as academic or artistic communications, political commentary or public debate done reasonably and in good faith, and that's where speaking the truth could be a defence in one of the exceptions. But apart from those, truth is not a defence to religious incitement legislation. Now, when Victoria introduced this law in 2001, very little thought was given to the implications of taking a paradigm from anti-racism legislation and transferring it holus bolus across to religion. But there are huge differences when you transfer something from the area of racism to the area of what is really ideology. Let me describe how this played out in the case of the Islamic Council of Victoria versus Catch the Fire in the aftermath of 9/11. This was a Christian revivalist group, Catch the Fire, and its leader, Daniel Nalia, invited Daniel Scott, a Pakistani Christian pastor, to run a seminar on jihad in Melbourne. One of the interesting ironies is that Scott had himself escaped from a blasphemy charge in Pakistan and escaped with his life in order to come to Australia, but he found himself charged with blasphemy against Islam in Melbourne in the Victorian Civil and Administrative Tribunal. Well, the Islamic Council of Victoria, hearing that this jihad seminar was being held, sent 3 converts to Islam to it, and they took notes, and a complaint was lodged on their behalf. Already before the case went to the tribunal, important lines were being drawn in the sand. The Christians asserted that they were criticising Islam and not attacking Muslims, and they insisted on their right to make that distinction between beliefs and persons. The Muslims, on the other hand, insisted that it was impossible to make that distinction and that criticising Islam was an attack on Muslims personally. As the lawyer for them said, if one vilifies Islam, one is by necessary consequence vilifying people who hold that religious belief. As it happened, many of the points of complaint involved issues that had some kind of factual basis. For example, it was complained that Daniel Scott had said that Allah teaches that taking part in jihad in the heat of the desert is preferable to the heat of hell. And actually that's literally what the Quran says in chapter 9, verse 81. But this factual report was taken to be an incitement of hatred against Muslims. The barristers for the Islamic Council insisted that, Brent Wanarski said, the mere fact that a statement may be true or an objectively justifiable expression of opinion does not prevent that statement from being seen as inciting hatred, contempt, ridicule or revulsion. The other QC for the Islamic Council, Debbie Mortimer, said, truth is not a defence, it is irrelevant to contravention of the act. In the end, the judge upheld the complaint. He found the 2 pastors had incited hatred, contempt and ridicule for Muslims. They were ordered to take out prominent advertisements in Melbourne's daily newspapers, reporting the findings against them at an estimated cost of around $50,000. They appealed and eventually won their appeal in the Supreme Court, and the Supreme Court judges were very critical of Judge Higgins in his findings. He made many errors of fact, but they particularly criticised him that he didn't adequately distinguish between rejection of ideas and rejection of the people that hold those ideas, and the possibility of inciting people against one without inciting them against the other. In a sense, the Supreme Court vindicated a key contention of the Christians that you can make a distinction between Islam and Muslims. It was a very long and demanding process that took about 4.5 years and was watched very closely by legislatures around Australia and overseas. I'd like to make a few final comments in this brief minutes to me about Islamization. Islamization is the process of conforming the whole of a society's institutions to Islamic requirements, including requirements on freedom of speech. Based on the example and the teaching of Muhammad, Muslim theorists have always regarded Islam as a system for the whole of life, which shapes criminal law, ethics, the military, government, and religious institutions. Islam does not traditionally recognize the distinction between religion and politics, but regards all of society's institutions as intended to serve religious purposes. Now, in the West, we are observing a pressure to Islamization on many fronts. These include requests to make adjustments to education, sports, family law, food regulations and provision, clothing, foreign policy, multicultural policy, as in this case it was through a vehicle of multicultural policy that an Islamic restriction on freedom of speech was being imposed, religious policy, the use of public space, finance, and in many areas. Now, the process of Islamization has 2 aspects. One is an intentional public aspect and the other is the more hidden hand aspect. The intentional process is expressed, for example, by active efforts to change school textbooks in America to ensure that they present an Islamic view of history, or the activities of the Organisation of the Islamic Conference through the UN. But there's also the hidden hand aspect, that is, Islamic theology influences Muslims, and they, in their own domain, wherever they are, over a large sweep of time and geography, have consistently acted to implement aspects of Islamic theology. And we're seeing this international process underway, limiting freedom of speech, particularly around criticism of Islam. There have been some sad concessions to this. For example, the refusal by the United Kingdom to grant Geert Wilders a visa to visit the UK. And in some cases, resistance to Islamisation seems to be very weak. In 2008, both the Archbishop of Canterbury, Rowan Williams, and Nicholas Phillips, Lord Chief Justice of England and Wales, suggested that the United Kingdom could consider, in the words of Phillips, embracing Sharia law. He argued that there's no reason why principles of Sharia law or any other religious code should not be the basis for mediation or other forms of alternative dispute resolution, and the Archbishop commented, "It's not as if we're bringing in an alien and rival system." The case of the Islamic Council of Victoria versus Catch the Fire was complex and very convoluted, but at its heart there were a few very fundamental issues. Can you criticise someone's ideas without being found guilty of attacking the person? And is speaking the truth a defence when you're criticising other ideas? Salman Rushdie had thought a lot about these matters, and he wrote about the values he'd learned as an undergraduate in England. If an individual in a free society no longer has the right to say openly that he prefers one book to another, then that society no longer has the right to call itself free. Citizens have the right to complain about discrimination against themselves, but not about dissent from their thoughts. There cannot be fences erected around ideas, philosophies, attitudes, or beliefs. It is sad to see the subversion of multicultural structures used to being imposed Sharia by the back door. Whether the West adheres to its historic convictions will determine its future. Far from sleepwalking into Sharia, I hope and labour for the cause that we will continue to claim the right to call ourselves free.